Under what circumstances might a parent be liable for the acts of their child? Generally not. Generally, in the American system of justice, the Anglo-American system of justice more generally, a party is only responsible, is only liable for their own acts. When we impose liability on a person who didn't actually do the thing that gives rise to liability, we are doing what is called vicarious liability, and it's generally disfavored. That said, there are exceptions. And on this side, you'll see that there's a civil and what I've referred to as a criminal-ish exception for which a parent can be liable for the acts of their child. So civilly, under 14.2/203, in addition to any other action, a property owner can go after parents of a minor under the age of 17 and over the age of 10 who maliciously and willfully damages or destroys that property owner's property, to authorize recovery from parents in situations where they would not otherwise be liable. So there's nothing to prevent that property owner from suing the parents for negligent supervision, for any of their own torts, or for any of their own failure to supervise their child. This statute goes above and beyond that and anticipates the situation where that property owner would otherwise be left without recourse, without remedy. The recovery, however, that they are allowed under the statute is limited. And it's limited to $2,000 in addition to taxable court costs, which go to the court, not to the property owner. So we're not talking about a huge recovery here, but it is something, and it does provide some financial incentive for parents to control their children. Section does not apply to parents whose parental custody and control over the child had been terminated by court order prior to the destructive act. That goes without saying because, as you'll recall, upon termination of parental rights is as if the parent is a stranger to that child and that child is a stranger to that parent. Note as well, to recover, the property owner must prove that the destruction was malicious and willful. This is a heightened standard as applied to the child that the property owner must prove to recover. So it's not easy, but it does provide something for property owners and to parents, a negative incentive to parents. Criminal-ish. Now, you'll recall from earlier that generally, unless one of those exceptions applies, the juvenile detained has to be released to their parents upon the parents' promise to procure the child for their appearance in court. Under 14.6/244, however, there is parental liability for the parent's failure to exercise reasonable control over authority. So generally, and this applies outside of the statute, a parent must exercise control that is reasonably necessary to prevent their child from engaging in a delinquent act. That parent can be financially responsible for a $500 probation bond if the child's delinquent act if court finds that the parent failed or neglected to subject the juvenile to reasonable control and authority, and that their failure to do so was the proximate cause of the act or acts of the juvenile upon which a finding of delinquency is based. So, in a delinquency case, a court can also ask the question whether that delinquent act would not have occurred but for the parent's failure to provide appropriate supervision. If it makes that finding, it can order a $500 payment effectively. The Office of Juvenile Justice and Delinquency Protection is an offshoot of the United States Department of Justice, and it sets standards for juvenile detention, namely the separation of minors from adults, that juveniles never be booked in the same area as adults. It's generally an idea of separation, that we want juvenile detention and incarceration to be qualitatively different from adult offenders, because we recognize that adult offenders are a bad influence. These are people who didn't receive the benefits of the juvenile court process, and we don't want to frustrate the protections that are otherwise afforded to juveniles by forcing them to mingle with people who may well be more hardened criminals. Note, however, that Wyoming is the only non-participating state to date. That certainly can change, but as of right now, Wyoming is the only non-participating state. What does that mean? It turns out not a huge amount, because there are some similar or analogous protections for juveniles in state statute. Under Wyoming statutes 7.1, 107, and 108. Juveniles can't be detained or incarcerated. Status offenders can't be incarcerated at all. Those juveniles who are detained or placed in shelter care have to be kept separately. So there is some protection, and you should be aware of the fact that juvenile offenders, whether status offenders or delinquency, those adjudicated of delinquent acts, are entitled to different treatment than an adult who proceeds through criminal court, or indeed for the juvenile who proceeds through adult court. Taking protective custody of a minor. So compare this to where custody of a minor is taken because they have committed a crime. There is probable cause to believe they've committed a crime. There's probable cause to believe they've violated a juvenile court order, or that reasonable steps are necessary to ensure their compliance, any of those exceptions we talked about earlier. Here we're talking about custody that is based upon the needs of the child, their safety, their well-being. So who can do it? First, law enforcement can do it if these circumstances are met, and there's the statutory reference for you. There are reasonable grounds to believe that that child is abandoned, is lost, is suffering from illness or injury, or is seriously endangered by his surroundings, and immediate custody appears necessary for his protection. So both of those have to be met. There must be reasonable grounds to believe that the child is injured, effectively, if I can summarize those. And it must appear that immediate custody is necessary to prevent further injury. Both of those have to exist. Or law enforcement can take protective custody of a child if the child's conduct or behavior seriously endangers him or herself, and immediate custody appears necessary. So it's very similar language as we saw in the circumstances under which custody could be taken in the law enforcement context. Here, we're talking about where the child could be injured by their own acts, their own recklessness, effectively. And reasonable custody is necessary to prevent that from happening. Medical professionals, as well, can take protective custody of a minor. And there we're talking about a physician, a physician's assistant, and a nurse practitioner. Those are the medical professionals who are mentioned in the statute. And they can do it similar to when law enforcement can. When that medical professional is treating the child, or work at a hospital in which the child is being treated, and finds that there is reasonable cause to believe an imminent danger to that child's life, health, or safety exists, unless the child is taken into protective custody, whether or not additional medical treatment is required. And there is no time to apply for a court order. So there's a lot going on right there. We're talking about a more managerial type medical professional there. So that's someone who's either directly treating the child or is supervising their treatment. They have to have reasonable cause that there's imminent danger. Can't be distant in time, it can't be foreseeable but speculative. It has to be an imminent danger to the child's life, health, or safety, unless they're taken into protective custody. Notably here, though, it doesn't have to be a danger that's related to treatment, because the statute says whether or not additional medical treatment is required. During the course of treatment, if something comes to that medical professional's attention that gives them cause to believe that imminent protective custody is necessary, then that can be unrelated to additional medical treatment. It could be non-medical, a non-medical need, a social, circumstantial need that requires that. And then finally, there must not be time to apply for a court order because, as in many areas of the law, the preference is that such detention be done only pursuant to a court order. But those are the circumstances under which law enforcement and medical professionals can take a minor into protective custody. So remembering here that the focus is on the child's interests, the child's health and well-being, not the prevention or investigation of crime. So what happens after the juvenile is taken into protective custody? DFS is notified to take that child for placement. That's Department of Family Services. They then prepare an affidavit for petition under the Child Protection Act. They will do that so that the petition under the Child Protection Act can be promptly filed. An abuse or neglect petition is then filed by the prosecuting attorney, or in some circumstances, the Attorney General's office. So remember, we're talking about protective custody here. That means that on our earlier spectrum of situations in which a juvenile might wind up in front of a court. Here we're talking about the situation where a child needs help. And so the type of petition is going to be an abuse or neglect petition. Someone has abused or neglected that child, and it is necessary, therefore, that they be brought in front of a court. Family Services may release protective custody. So after all of that, Family Services can release protective custody only with the approval of the prosecuting attorney. The idea here being, we wouldn't have made it this far if there wasn't a strong basis to believe that protective custody of this child was necessary. And so DFS can't release that custody on their own. The prosecuting attorney has to be involved. And what thereafter follows is a very complicated process, which is rather beyond the scope of our need today. But it involves the parents, those accused of abuse and neglect, so that could also be a guardian, the children themselves who are the subject of the petition, and the state who is prosecuting that petition. And it's broken down into a number of phases. First, there's the investigation phase. And some of that has already occurred because the petition has been filed, the child has been taken into protective custody. But that investigation needs to be completed. And an initial hearing demonstrating the status of that investigation, its progress, must be held within 48 hours. Similar to the detention or protective custody, or excuse me, the shelter custody hearing that must be held that we discussed earlier on. After that initial hearing, there's an adjudicatory phase, the fact-finding phase, which is the equivalent of a trial. Here, I'm not going to say that it's the equivalent of a criminal trial because the case isn't against the minor. It's not against the juvenile, it's against the parent. And so the focus here is, it is much more analogous to a civil trial, fact-finding. Then there is the dispositional monitoring phase. After the juvenile court has determined that the abuse or neglect has occurred, that the placement should continue, whatever it determines, that is monitored for a period of 12 months to determine whether or not the abuse or neglect has abated, whether the parents are making progress toward any goals that the court established for them to prevent future abuse, neglect, etc. Finally, there is a permanency phase. And at this phase, this could proceed to termination of parental rights if the parents have failed to comply with whatever the orders of the adjudicatory phase as monitored by the dispositional phase, or it could proceed to reunification, which is certainly the goal of all of these types of cases where families are reunited. Remembering, however, that the child's health, welfare, best interests are what is paramount. So abuse or neglect, these are vague and broad terms and can appear either civilly, criminally, or both. What we just discussed was civil abuse or neglect, where the state proceeds in an abuse or neglect petition against the parents, legal custodian, responsible adult of a child. And that process ends in termination of parental rights, or prior, if reunification is achieved. There's also criminal liability for abuse or neglect, and that arises under the Wyoming Criminal Code for assault and such crimes. Juvenile court abuse or neglect, and what we're talking about here is the latter. Excuse me, it's the former. We're talking about that civil idea of abuse or neglect, where the ultimate goal is either reunification or termination of parental rights. Reunification being the preferred outcome, termination of parental rights being the necessary outcome if reunification is unable to occur. And it's civil. These are not mutually exclusive. The criminal court, the prosecuting authority of a jurisdiction, can proceed against a parent criminally if the abuse or neglect meets the requirements of state statute. And so that case would proceed in criminal court. The child wouldn't be involved directly. Any involvement they would have would be as a witness, as would any victim to any crime be involved. CHINS, child in need of supervision. Now, this arises under 14.6.202, and that's the definition of what is a child in need of supervision. So it's any child who has not reached their 18th birthday, who is habitually truant, remembering that truancy is a status offense in Wyoming, or has run away from home, or habitually disobeys reasonable and lawful demands of his or her parents, guardian, custodian, or other proper authority, or is ungovernable and beyond control. So there's some antiquated language in there, but the idea is that this child is, and it's captured by that last section, the child is ungovernable and beyond control. The state needs to get involved. The child is in need of supervision. So that includes any child, just to summarize, who has not reached his or her 18th birthday, who has committed a status offense, and that falls under the definition that we just mentioned there, but to be more specific. Now, there are a lot of resources out there and collaborative agencies recognizing that children are often victims. They're disproportionately the victims of crime. They are disproportionately forgotten by a lot of legal systems. And so there are a lot of authorities out there that are designed to protect them, to support them as they proceed through a world that might be unknown to them, that might be uncomfortable. And so here there's just a list of some, and this is not all-inclusive. The first, CASA, Court-Appointed Special Advocates. These are people who represent the interests of children. They may or may not be attorneys, often they're not, and they basically provide a voice for children in civil type cases and advocate on their behalf. Guardian ad litem, this is a part of the State Public Defender's Office, so each county, as does the State Public Defender, has a guardian ad litem, or it could be done at a district level, and they act as the attorney for the child in the delinquency case. They are attorneys. CAC, that's the Children's Advocacy Project Center. The term sort of changes. A great source of information, more sort of a public interest group. And then finally, there's the Children's Justice Project, which is part of the Wyoming Supreme Court. The hyperlink is here on the page, a fantastic source of resources. If you have any questions, if there are any issues that come up, this is, as I mentioned, a project of the Wyoming Supreme Court. And so what they say here carries a tremendous amount of weight, and it's a phenomenal resource. So some quick review. Why do we treat children differently? Why have you had to watch this video? It's the purpose of a separate juvenile court system or process is to protect and rehabilitate youth who are less culpable, and to facilitate, where appropriate, intervention and family reunification. So that's sort of the why, right? We have a criminal process because those people have broken the law. We have a separate juvenile court process because those juveniles may well have broken the law, but there may be a legitimate excuse. There may be a reason why we don't want to put those people in prison or subject them to standard criminal sanctions, but instead give them an opportunity to turn their life around. How do we do that? So it's similar to the adult system in that it provides certain procedural protections, and it adopts a quasi-criminal structure together with trial-like rights. But it differs in that it focuses not on whether or not the crime was committed necessarily, not directly, but instead on the best interests of the child with the goal of rehabilitation. And it does that by requiring procedures that generally are fundamentally fair. So we lack, remember, the specific constitutional protections that are afforded to a criminal defendant, Fifth, Sixth Amendment. Instead, these arise under the 14th Amendment protection of due process and require that the delinquency proceeding, the CHINS proceeding, any of these be fundamentally fair. When? Juvenile can be taken into custody under same circumstances as an adult suspected to have committed a crime, and also for juvenile-specific bases, implicating safety and protection. That's how they enter the system. That's from which flow the other issues that we've discussed. So here's my contact information. Again, Phil Donahoe, Wyoming Attorney General's Office. If you have any questions, please don't hesitate to contact me. There's my email address. There's our number at the Criminal Division. It will be our pleasure to help you and to ensure that these issues are resolved quickly.